All right, let's be on the record in case number 2018 CR 322, captioned State of Kansas versus Tyler Giles. Would the parties announce their appearances, please?
May it please the court, the state of Kansas appears virtually through Assistant District Attorney Adam Sokoloff.
Your defendant appears in person via Zoom and through his attorney, Craig Lubo, also via Zoom.
All right. Record should reflect that in this case, there was a plea agreement reached in the underlying case. And on June 22nd, the defendant was sentenced to a controlling term of 12 months in the Department of Corrections, and he was granted probation at that time. Then on February 27th of 2019, there was a motion for probation revocation. That was set for hearing. The defendant failed to appear. He was picked up on a bench warrant. And that hearing was held on October 18th of 2019. The defendant stipulated the violation at that time. He was given a tier 1 3-day sanction with credit for the time he had been in, and his probation was extended for 12 months from that date. On October 19th of 2020, a new motion for probation revocation was filed. There was an order of appearance issued. The defendant failed to appear for that hearing, and a bench warrant was ordered. He was picked up on that bench warrant, set for hearing in a couple of weeks. At his request, in order to expedite this matter, the defendant requested that we move this hearing forward to today's date by Zoom. I would note for the record, although invited, we have not heard back from the probation officer, but prior to coming on the record, both defense counsel and defendant indicated that they were not contesting any of the 9 allegations in the state's motion. Therefore, they wish to proceed with this hearing even in the absence of the probation officer. Mr. Lubo, do I have that correct?
Yes.
And Mr. Giles, is that correct?
Yes, Your Honor.
Okay, so I would take it then that you are stipulating to the 9 violations contained in the state's motion.
Oh, yes, Your Honor.
Okay.
It's just like I didn't complete my probation terms. It's just like, it was just probation. I didn't complete them. I did show up to the probation. It's just I didn't complete everything. And then I guess all the terms like goes with that,
Okay, we'll talk about that here in a second.
Okay.
Mr. Sokoloff, I have a question for you. It looks like on October 18th of 2019, I extended the defendant for a year. This motion apparently was not filed until a year and a day later. What's your position on that?
Well, Your Honor, I have to admit that I hadn't put that date issue together yet.
I just noted it when I was reading it to the parties. I believe that the state has the opportunity to file such a motion. And look, it's been a long time since this issue has come up, and I think as a practitioner, not a judge, there were 30-day leeway after the expiration to file any violations. That would make it such that if a defendant, let's say, committed a crime 2 days before his probation lapsed, that there was a reasonable amount of time for the state to be able to react to that. So I think there's a 30-day leeway. I'm just not, I'm not really clear what's going on here, because it appears from a couple of the things, from the contents of the motion and the fact that the defendant did not appear at the time of the hearing, that he was not, he had basically absconded from what these allegations are and why they would wait until a day after the expiration of a probation term to file such a thing is a question that I have. So I guess that's what, if I'm doing it correctly, I put the court's concern about that out there.
And Judge, I think there's some leeway, but in light of the example you used, I'm not sure, I haven't researched that, if that's universally the case or if there has to be specific situations, because if he commits a new crime, that's something new that they didn't have the opportunity necessarily if he commits a crime 2 days before the expiration. Whereas in this type of situation, it's all relating just to reporting, and they obviously knew for a year that he wasn't reporting. So I don't know if that 30 days would apply in that situation.
Well, again, I think that's the underlying rationale why they give that extra time. I don't know that if that's not the factual scenario that led to it being filed after expiration, that necessarily makes it not prosecutable. I don't know. Yes, Mr. Sokoloff.
Okay. Your Honor, ordinarily that is an issue, but I'd cite to the court 2237-16, specifically subsection E as in Edward, which allows the state the 30 days from the conclusion of probation or when it was set to expire, even with extensions, for any reason. There is no new crime requirement or anything like that. Additionally, I will point out to the court that I believe, and I could be wrong, that the arrest that occurred at that time there close to the end of the expiry of probation was, while not filed, and I'm not using it here today, but I think that might have explained the thinking of the probation, was I think he was also arrested for robbery at that time, though no charges were filed. That's what Blue Horse shows from October. So, and the KCK bench warrant at the same time, that pickup was for 3 different things, at least that's what Blue Horse indicates. That might explain why probation then got Mr. Giles back on their radar. But regardless, it was clearly within the 30-day period provided by 3716.
I agree. So anyway, Mr. Sokoloff, we have a stipulation. What's your position as to disposition?
I will say, Your Honor, I would understand why reasonable minds could differently interpret the situation we find ourselves in. While I will say that the defendant's violations are only technical, at least that's sort of a term of art we use, there are no new crimes, there's nothing like that. What it appears is an almost complete failure at probation. I mean, every conceivable term that was asked of Mr. Giles was not fulfilled. I think I can't think of another material term, quite frankly, that he could have failed on. I will also say that he got a remarkable plea deal given the initial charges. One that I still, I think about, and I will say that there were a number of factors that the court might be able to guess at, unrelated to what's read in an affidavit, that might lead the state to bargain a case like this down to what it was. But at the same time, the facts in this case were astoundingly reckless and could have ended in such a crazy and terribly tragic way that it's, I almost chuckle at it, not because it's funny, but just because of sort of the absurdity of it and how it ended. Now, the only thing that was asked of him was to do your probation and pay off restitution, and nothing's happened. I don't know that the court has any reason to believe that it's going to start happening, particularly.
No, I tried. I showed you probation.
I'll listen to you here in a second, Mr. Giles. Don't interrupt the prosecutor.
Okay, I'm sorry.
You are going to have your opportunity for sure.
Okay.
Particularly given the court's highlighting of how long this case has gone on, and the court afforded another year entirely for Mr. Giles to prove that he could do something. And I don't know what the legal term is. I use a sports term, and I apologize to Miss Lowe, your court reporter, but he's over. He's O for all things asked of him. The motion from Mr. Lovin, the probation officer, requests revocation because a tiered sanction obviously didn't wake him up, or an extension. I will note to the court that his underlying sentence is 12 months. I believe that he served approximately 70 days. And I don't think there's any reason for any of us to believe that he's going to be successful under probation. So I'd ask you to revoke him and impose a modified underlying sentence of 9 months.
All right, Mr. Lubo.
Okay, Judge, I would ask that the court consider a tier 2 sanction, which he's already served. He indicated to me that part of the problem, and this doesn't apply to everything, but part of the problem was the COVID situation that has just about made it impossible for him to find employment. And of course, without employment, some of the other things like paying restitution fees becomes impossible at that point. He's indicated he has been searching for employment. Beyond that, I don't know what to tell you, because of course it's going to be difficult to do anything till he finds employment. But he says I told him at the very least, if he can't go in person, he can certainly be calling the probation officer every week at the very minimum, so that they don't think he's absconded or that he's just blowing it off. And I told him I would ask that you allow him to speak as well.
Absolutely. All right, Mr. Giles, now is your opportunity to tell me everything you need me to know in deciding what to do with this case here.
Okay, Your Honor. First off, however he's trying to make me seem, I'm not that type of person. I'm actually a good kid, Your Honor. I haven't got into any other serious crimes. I actually did show up to probation multiple times, and you can ask the probation officer himself, the probation officer, Mike Lovin. We actually had some problems, some issues, so that might be a reason why he's not here today. Actually, I actually reported him one time for actually calling me a son of a bitch one day, or excuse my language, but so I reported him on that. And then basically, I haven't committed any new crimes, Your Honor. I tried last year after I did get out on this. I came to probation multiple times. And then after that, it was like COVID hit. I was calling like every week. They said the office was closed. I couldn't get in contact with nobody. I left multiple messages, and then that's all it was. I mean, I can pay my restitution, all that. When I get out, I can pay something today if you let me out. Or even if you want to keep track of me, I can do house arrest, or even send me to the rehabilitation center. I'm not gonna lie, I do probably need a little help or some guidance, whatever, but it's not enough to, I'm not a bad person to send me in jail, for 9 months or whatever. Like this time, like I feel it woke me up. Sitting in this jail, actually, like it woke me up. I mean, I got 2 small children. Their mom's the only one that watched them. She can't even go to work while I'm in here. It's either me or her. I mean, other than that, like, I'm not gonna be able to do nothing sitting in here. Like my kid's birthday's coming up. I can't do anything. And then like basically, like I don't want that to affect them. That's something that happened years ago before they was even born. So like if you could just like work with me this time, I promise I won't let you down. I'll show you. You will never see me sitting in front of you again in this jumpsuit. If you hear about me, it'll be something good. I just want to work on myself and do better.
All right, thank you. Look, Mr. Giles,
Yeah, sure.
your performance, and I want you to know this, I don't take into consideration at all the state's, what the deal was and whether it was a great deal or I deal with what you were convicted of and the sentence that you were given.
Yes, sir.
You were placed on probation, and at the time of the first motion back in 2019, you were basically doing nothing on probation, and you stipulated to that fact. They gave you 3 days and let you out because that's what we have to do when somebody is on a presumption probation, they haven't committed a new crime. And the whole
Yes.
idea of the 3 day is to give you a bad taste, to go,
Yes.
if you do this again, this is what it's going to be like, but it's not going to be like 3 days. It's going to be your entire sentence. You turned around after that, and then, and there is only one way to, and look, I gave you the opportunity to have probation officer here, and he could explain or even confirm or deny those things that you're saying that you reported all the time, and
Yes, Your Honor.
that you got in I don't know. I'll tell you this, Mr. Lovin, I think was a probation officer here before I took the bench 14 years ago. He was up in Leavenworth County and for a while, and then he's been back here over a decade or so. Whatever you think of him, I don't think I've ever heard
Yeah.
foul language come out of his mouth.
He apologized to me.
Of all of the things that he does or doesn't do, my knowledge of him is like he has a personal thing about the use of foul language. So if you told me he called you a no good, dirty scoundrel or something like that, I'd believe you. You tell me he called you an SOB, I don't quite buy that.
No, I reported.
But here's the long and the short of it.
Yes, sir.
What I'm afraid happened here.
Okay.
You didn't do your probation
Cutting.
at all.
Judge, you're cutting out.
Yeah, my emails came in. All right.
Here's the long and the short of it. Can you start right
Here's
after?
the long and the short of it. You didn't do your probation, and you didn't show up for your court date, and you showed then when you got arrested, they gave you 3 days and let you out. I'm afraid what that did was send you a bad signal that said, hey, guess what? Don't do your probation again. Don't show up for your court hearing. Get arrested. They'll give you 3 days and send you on your way again. But that's not how it works. That first date, that first time was your bite at the apple. For some reason, the prosecutor has asked to cut 3 months off your sentence. And I guess if the prosecutor thinks that that's something that I should do, then I'll do it. But you're going to do your time. If I were to put you back on probation, to me, that would
I
be
promise, Your Honor, I
that
will.
would be an acknowledgement that I'm not really serious about making goods. There's nothing in this that would say to me, I think that Mr. Giles will do what you tell him to do this time. And you've been warned, and all of those, I don't know what you thought was going to happen, but you've really given me no choice but to impose your sentence.
Your
I'll
Honor.
go along with the prosecutor. I'm going to modify your sentence, reduce
Your
it
Honor.
to a controlling sentence of 12 months to 9 months. You'll be
Your Honor.
credited every day you've served, and you're also eligible for your 20% good time credit. But the sentence imposed, as modified today, is hereby executed.
Your Honor. Could you please send me to a rehabilitation center where I can be washed or something, please?
They have drug treatment in prison. I don't have any sort of
No, like the
medium in secure place to send you to. That's a question you should have been asking your probation officer over these last 2 years.
could you do house arrest, Your Honor? I got 2 small kids, Your Honor.
I
Please.
understand, and it's a shame that they're going to be without their father for a while. But look, it's a very thankfully to the prosecutors' forbearance. It probably is only by the time you get your good time credit. Let's see, if you're doing 9, you've already done 2 plus. So you're looking at 7, you get 20% off of that. You're going to be looking at another month and a half off. You got about 6 months to do. And I think that's probably a pretty good lesson and would probably keep you from thinking about doing things like this again. That's the court's order. Anything else for our record today?
Nothing further.
Yes, Your Honor. So, can you tell me how many times, how long have I been in jail? How many, like, do you got the exact number?
The prosecutor indicated it was 70 days. Was that calculated as of today, Mr. Sokoloff?
It's either 69 or 70, Your Honor. I have to go back and look at it at the last sanction period, but approximately over 2 months, less than 3 months.
Because I know the first time I came, I did 3 months off, like the first time, and then the second time it was like at least another month.
Our records indicate 56 days and I believe 14 days.
All right. Well, I can see how that could feel like longer if you were actually doing it. All right. Figure that out, Craig. When he get the journal entry, double check it, make sure Mr. Sokoloff is right. He's been known to make one mistake a year, and this might be it. Check and see. We are adjourned. Thank you, everyone.
So, do I have a